I mean, this is kindergarten constitutional law. You don't really have to go to Harvard Law School. In fact, probably better for you to stay far away from Harvard Law School if you want to learn this. So there we have it. Now, where did that appear, sir? Security? Second Amendment. Okay, Second Amendment. So let's read the rest of the Second Amendment. A well-regulated militia being necessary to the security of the free state, comma. Now, if you were a student of Latin, you'd call that what they used to call an ablative absolute. Oh, I used to read that all the time in Latin, right? Caesar having come into Gaul with his legions, right? The Belgians were afraid and retreated across the Rhine. That's the kind of a phrase. In English, it would be called a nominative absolute because we don't have ablatives in English. We don't have all those cases. But typically, that kind of a phrase is where perhaps the most important part of the thought occurs. The most important part of that thought from Caesar's commentaries was not that the Belgians crossed the Rhine, but they were afraid of Caesar and the legions, right? I think Caesar was trying to tell us that. That's why he put it that way. Well, the Founding Fathers wanted to tell us something with this nominative absolute. A well-regulated militia being necessary to the security of the free state. The consequential thing here is to maintain the free state. That's why we're looking at this phrase, maintain the free state. And then there's this thing that's necessary to that. You know anything else in the Constitution that the Constitution tells us is necessary for any purpose? Any other establishment or institution? Does the Constitution say Congress is necessary? No. The President? No. The Supreme Court? No. It doesn't even say that the states are necessary. They probably are because they're part of the federal structure, right? But it doesn't say that they're necessary. The only establishment that says it's necessary to security of the free state is a well-regulated militia. Okay. Now, one would think that that's a serious statement, put in that absolute sense. Now, what is a well-regulated militia? Well, you look in the Constitution, it's not defined. The Constitution is not a dictionary. Does that mean it's not important? No. All sorts of important words are not defined in the Constitution. Jury, trial by jury, Republican form of government, piracy, felonies, the law of nature. You can run down a list of these things that aren't defined. Dollar isn't defined. Some things are defined. Congress is defined because it was a completely new assembly. It had new powers, new structure. They didn't want to confuse with the Congress under the Articles of Confederation. President, that office is defined. There had never been a president before. It was a completely new office. The judiciary, its jurisdiction is defined. Why? Because it was going to cover cases and controversies that had never been seen before, anywhere in the world. It had to be defined. Treason is defined. That's an interesting one. They define treason very narrowly. Levying war against the United States or giving aid and comfort to the enemy. And you ask yourself, well, why did they do that? Well, because treason under English law, if you read Blackstone's commentaries, which is the standard text, legal text at the time, goes on for page after page after page of the definition. Treason had been expanded in order for the king to use as a political weapon against his enemies. And the Founding Fathers didn't want treason to be used as a political weapon. They had known that it had been, and so they had to define it in a very narrow way to exclude all these other possibilities. Now the militia they don't define. And it's fascinating because they don't define it in the Second Amendment, but they also don't define it in the original body of the Constitution. That's the Constitution as it was originally ratified before the Bill of Rights showed up. If you go to Article 1, Section 8, Clauses 15 and 16 talks about the militia. Actually, the militia in plural. It talks about them as them, the militia. If you go to Article 2, Section 2, Clause 1, President's Commander-in-Chief of the militia of the several states when actually called into the service of the United States. That's interesting. The militia of the several states. The Constitution recognized that there are, at that time, 13 of them. Now 50 of them. There's one in each state. They're state institutions. But it also doesn't define them. And the reason was that they didn't need definitions. Just like terms, jury trial, law of nations. That was well known the definition of those were well known to the people in those times, especially militia. Why? Because every adult, able-bodied adult male at least, at that time when the Constitution was ratified, was a member of one of these entities. And he'd probably been a member of one of these entities for a long time, and if he hadn't had some kind of exemption, he had probably fought for some time in a militia during the War of Independence. And if you were old enough, he probably would have been engaged in militia activity going back to the French and Indian War of the late 1750s. Right? And in fact, if you go back in the books, you will find militias existing into the early 1600s. In fact, every colonial charter that I ever read, the king's grant to his friends of some kind of special privilege to come over and found a colony of one kind or another, had a provision in it allowing the proprietors, these friends of the king, to set up some kind of militia structure. Why? Because they were going into a essentially very hostile, potentially very hostile territory. Not only were there natives, the Indians, but they might have to deal with the Spanish or the French or early on the Dutch. I mean, you think the English had a number of enemies. So this system goes back, the militia structure goes back into the 1600s. The one thing that's fascinating about it is if you read all of the statutes that were passed in all of the 13 colonies, and I have, they're all the same. They follow exactly the same pattern. Again and again, they were reenacted over and over again, exactly the same pattern. That was the pattern that defined a well-regulated militia. In fact, that's the title most of these statutes have. An act to regulate the militia of such and such. An act to amend an act to regulate the militia of such and such. An act to better regulate the militia of so and so. It goes on and on and on like that. Their understanding of what a regulation was this statutory set of instructions as to how you formed these things and operated them, what their equipment was going to be, what their duties were going to be. And they must have thought that those statutory structures were well regulated because they kept reenacting them over and over again for approximately 150 years, if you go all the way back to Massachusetts. That's the first one. So we can tell what a well-regulated militia is simply by going back to that set of statutes and pulling out the principles that we find in each one of them. Well, what's the first one? A well-regulated militia was of universal membership. Now, they had slaves, and the slaves couldn't possibly be allowed to serve in the militia because of another principle, which was that the militiamen were armed. And slavery is incompatible with arming the slaves. One can see that pretty clearly. All right. Now, that didn't mean that the slaves didn't have some role, because in some of the states they brought them in to work as laborers. All right. But slaves were excluded from the militia for the obvious reason. Women were not excluded from the militia, but they were, for all intents and purposes, exempted. And the reason being was that under the social and theological, really, mores of the time, it was not considered appropriate that women should serve in some kind of paramilitary activity in which combat duties in those days certainly filled a very large percentage of the time. Now, that didn't mean they didn't have some role, because it turned out minors, M-I-N-O-R-S, not guys who dig in the ground, but children, minor males, usually from 16 or in Massachusetts 15 up, were required to serve in the militia. Most of these people didn't have incomes of their own. They might be apprentices, they might be servants. They probably came from families where the father was just earning enough. They certainly didn't have jobs that were giving them sufficient money to do what? To buy the firearms that the militia required them to buy. I'll get to that in a moment. They were all required to buy their own guns.